Thank you, Senator Feinstein. Senator Lee.
I think it's easy for us to take for granted and overlook the extent to which we've all benefited from living in a country that operates under the rule of law. In order to have the rule of law, as opposed to the rule of individual men and women who serve within a government, you really have to have some kind of structural protection in place to protect the people against the risks with devastating consequences associated with the excessive accumulation of power in the hands of the few. It was for this reason that some of our leading legal thinkers, including, I remember 12 years ago when I first arrived in the Senate and came onto this committee, within a few months or so of my arrival, we had a couple of Supreme Court justices visit. Justice Breyer and Justice Scalia came to talk about the courts. As I recall, they did that from time to time. It was something I had seen before. I'd seen them do sort of this roadshow exercise in which the two of them would play off of each other, sometimes telling jokes at each other's expense, but always in a good-natured way. It was during one of those visits, and I believe it was in this very room, when Justice Scalia said something that has stuck with me. He referred to the fact that, along the lines of what Senator Cornyn was just describing a moment ago, in a lot of countries, there's a constitution. It might even be written on a single document like ours is. And it might even contain a Bill of Rights that looks really good. It protects most or all of the individual liberties that our Bill of Rights seeks to protect. In some cases, even lists more protections than ours does. But as Justice Scalia explained at the time, any tin-horn dictator anywhere in the world can have a Bill of Rights, and that Bill of Rights can look really good. By the way, I've never understood what the difference between a tin-horn dictator is and a regular dictator. He didn't explain, and he's no longer here for me to ask him. His point was clear. A lot of countries, including and especially those with tyrannical governments, have bills of rights. What he said next was intriguing. He said, what differentiates a Bill of Rights that means something from one that doesn't is a mechanism by which you can separate out power, allow power to check power, and thus protect the people from the dangers associated with the excessive accumulation of the power and of power in the hands of the few. A sine qua non of this really is an independent judiciary, a court system that stands separate, detached from the political operations of that government. Now, in our system, of course, we've got the three branches. We often refer to our branch, the legislative branch, together with the executive branch, headed by the president. We call those the two political branches. And by calling them that, we differentiate them from the court. The court, although it's populated by people who have to go through the political process, having been nominated by the president, confirmed by the Senate, once they're put in place on good behavior, they remain there for the rest of their lives, absent other circumstances. This really is an essential part of having an independent judiciary. And without the independent judiciary, there can be no rule of law. And it's easy to overlook all the benefits that we reap every single day as a result of that. We're known throughout the entire world as a country where the rule of law is a thing, where if you enter into a contract, there will be a mechanism by which the terms of that contract can be fairly interpreted and enforced and enforceable in a court of law. This is one of the reasons why businesses from countries all over the world want to do business in America. They're looking to invest overseas. They may not want to invest as much in some other countries as in the United States. In fact, they almost never would prefer, when faced between the United States and another country, in many circumstances, in many industries, they'd rather do business in the United States if they can, in part because of this reason. We've all benefited economically and otherwise as a result of this. But this system isn't free, and it's not self-perpetuating unless we consciously, deliberately choose to protect it. And protect it we must, because you can break it. This is legislation. It is a solution looking for a problem. And it's a solution looking for a problem. It's carried out in such a way that can make a whole lot of things a lot worse, and that would, in fact, accomplish something very different than the lofty descriptions that you're hearing from its supporters today. Look, if the sponsors of this bill and those who plan to support it, if they were truly interested in ethics and integrity within the Supreme Court of the United States, I think they would have conducted this debate and this inquiry in a very different way from the beginning. And I think we would be seeing some of those differences now. I think also that it's important to recognize that the Supreme Court of the United States does, in fact, have ethical standards. It does, in fact, have its own ethics rules that it supervises, that it oversees. We do, in fact, have a judicial conference that can and does look into these things to overlook them. Now, you'll hear from the bill's sponsors today, and you've heard some of this already, and well, those aren't nearly enough. They're not good enough. They're lax. It's basically a post-apocalyptic hellhole over there from an ethical standard viewpoint. This is utterly false. It's not true. It is objectively untrue. It's slanderous, and it's deliberately slanderous so as to undermine the credibility, the reputation, institutionally speaking, of the court and its justices. Or I correct myself, I should say some of its justices, and I'll get back to that in a moment. But they do, in fact, have ethical standards. And in fact, in many meaningful respects, those standards not only match up to those that we follow, in some meaningful ways, they exceed those that are binding on members of the United States Senate. For example, in the United States Senate, we don't have the same recusal standards that they do. One can be a soybean farmer or a tobacco farmer and a member of the United States Senate and still vote on bills relating to subsidies for soybeans or regulatory issues associated with tobacco. We don't have recusal standards there. There are other differences, but this is a good one to highlight. Some of these differences, you see, reflect differences in the role that we play versus the role that they play. So to look at theirs and say, oh, that doesn't matter, that it's not adequate, all hell is breaking loose over there. It's just not true. And it's deliberately, or at least recklessly, but I think deliberately deceptive. But look, this thing really would have played out differently if the sponsors of this legislation were truly interested in an even-handed way of enhancing integrity at the Supreme Court. There are glaring instances in which there have been activities undertaken by Justices Ruth Bader Ginsburg, Justices Ruth Bader Ginsburg, Sandra Sotomayor, Stephen Breyer, and others that raise some serious questions under the rules and standards that currently exist. Notwithstanding those, in all those examples, with one glaring exception, I don't think there's any of us in here who would credibly maintain or contend that any of those things, any of those issues related to the democratically appointed justices I just mentioned, or to that of Republicans, none of those things amounts to something that could or would or should result in impeachment, removal, criminal prosecution, or something like that. If those things arise, there are remedies to do that. There are ways that we can remove a justice who is engaged in a high level of wrongdoing. But that's not on the table here. This is part of why I maintain this is a solution in search of a problem, but it's a solution that would cause a lot of other problems. Because the solution that they propose is one that would completely remake, it would reinvent the Supreme Court. It would reinvent the litigation strategies that go into handling cases before the Supreme Court. You see, because if a person can just, by filing a document or making an accusation, trigger a review panel of lower court judges whose rulings it's the Supreme Court's job to review, and in many instances reverse, it won't be long if this becomes law before it'll be considered malpractice for attorneys practicing before the Supreme Court to fail to try to trigger through these aggressive mechanisms a recusal and to cast even more doubt on the credibility and institutional reputation of the Supreme Court of the United States. I think that's very, very unfortunate. This really will change the game because in some of those circumstances, if this were to become law, they'd succeed. Especially in a politically charged case. They'd figure out a way to get one of these panels of lower court judges to order the recusal of this or that justice in order to inflict their own carefully designed Supreme Court for that moment. You know, when lawyers go to trial, they go through the process of jury selection. In most parts of the country, we call that voir dire. Only in Texas, they call it voir dire. I don't really understand the difference in pronunciation, but Texans, they do things their own way. Each side gets their own opportunity to object to each juror. There are two kinds of challenges to a would-be member of the jury panel. You've got for cause challenges. You can challenge somebody for cause. You know, potential juror knows the defendant or the plaintiff, the prosecution or defense, or has some type of conflict, either side can challenge that and have that person removed from the jury panel. But the other kind of challenge is what we call a peremptory challenge. You can remove a small handful of jurors for almost any reason or no reason at all. It seems to me that this legislation would, in effect, treat the Supreme Court justices, approach them in almost the same way one might approach a potential jury, with the attorneys having the opportunity to remove individual justices whom they might consider problematic for their particular case. So at the end of the day, we look back at the fact that almost none of these instances really rise to the level of criminal wrongdoing or impeachment and removal. I don't see it. It's not there, not on the Democratic appointees, not on the Republican appointees.
Senator,
I do, however, see one of them.
Senator, if you could wrap up, we have the other committee meeting now. And
I understand that. I've got things to say on this, and we have always allowed members to speak.
I hope all members have a chance to do that.
Oh, okay. I will wrap up with all deliberate speed.
What about your chart?
I'm getting to that in just a moment. There is one exception that I'm talking about. There is one allegation that's come to light fairly recently with regard to the late Justice Ruth Bader Ginsburg. Now, Justice Ginsburg, while I disagree with many of her rulings, she's someone for whom I've long had deep respect, but there are some very serious allegations that have recently come to light that I've recently become aware of, to the effect that she received a $1 million award that went unreported. Now, I'm still reserving judgment as to exactly what to make of that. That's the only one of them that I would say, yeah, that one, this might have some very significant ramifications. If she were still serving on the court, if she were still alive, that might lead to something. Even there, I feel the need to qualify that because I don't yet know all the facts of it. Those haven't all come to light. We don't yet know exactly what was done with that, whether she carried out the apparent intention or the stated purpose of intent at the outset to donate it to charity. There's a lot we don't know there. But that's an example of something that could be more significant. The other things that we're talking about are not things for which anyone in this room could credibly maintain is the stuff of impeachment and removal. So, look, I've got colleagues on this committee on the Democratic side who like to talk a lot about dark money on the right. But let me tell you a little bit about how liberal dark money is funding these activist hit pieces underlying this legislation and the perceived need for it on the left. These activist hit pieces written by ProPublica, while also funding the activist groups calling for court packing and supporting this legislation openly, actively, aggressively gunning for it. This is the same ProPublica that publishes hit pieces on Justice Thomas and on Justice Alito, while simultaneously turning a blind eye to other conduct from those justices appointed by Democrats. Even and especially a $1 million award given to a democratically appointed justice. Look, this chart details some of this, about the Sandler Foundation launched by ProPublica. The Sandler Foundation, rather, launched ProPublica and remains ProPublica's largest donor. Now, the Sandler Foundation also funds the Campaign Legal Center and the American Constitution Society, known in the industry as ACS. Both organizations publicly called for the investigations of Justice Thomas shortly after ProPublica's hit piece on Justice Thomas. These hit pieces cited experts from the Campaign Legal Center and from ACS. The Sandler Foundation also gave money that Arabella Advisors' new venture fund had earmarked for Demand Justice, which, as many in this room know, is an organization that advocates for court packing and has openly and aggressively called for Justice Thomas's resignation from the court. The Silicon Valley Community Foundation gave money to ProPublica and Citizens for Responsibility and Ethics in Washington, or CREW. CREW sent a letter to Justice Thomas calling on him to resign. The Marisala Foundation also gave money to ProPublica and to CREW. George Soros' foundation to promote open society is donated to ProPublica, the Campaign Legal Center, and CREW. The William and Flora Hewlett Foundation is given to ProPublica, the Campaign Legal Center, the American Constitution Society, Alliance for Justice, and Fix the Court. And the Ford Foundation has funded the Center for Popular Democracy and the National Women's Law Center. Both organizations called for Supreme Court reform based on ProPublica's reporting. I will close by winding back for just a moment to the whirlwind. The whirlwind quote raised by Senator Kennedy just a few minutes ago. What was that whirlwind? What was Chuck Schumer saying on the Supreme Court of the United States steps that day? He stood on the steps of the court. We will unleash the whirlwind. You won't know what hit you. Justice Gorsuch, Justice Kavanaugh. Actually, I think he just said Gorsuch and Kavanaugh, leaving out their titles. What was it? Was it, was the whirlwind the guy who traveled great distance and arrived at night outside the home of Justice Kavanaugh to kill Justice Kavanaugh? Was that the whirlwind? Was the whirlwind the blatant refusal to enforce 18 U.S.C. 1507 as against those terrorizing, sometimes daily, often weekly, or on some other semi-regular basis, the families of Supreme Court justices by protesting outside their homes, allowing those protests to take place, and then refusing to enforce federal law that makes that unlawful to do that at the home of a Supreme Court justice? Or was it these attacks impugning the credibility and character of jurists who have worked a lifetime to build reputations for themselves, reflecting on the court of credibility, even-handedness, and fairness? Perhaps that was the whirlwind. If so, this is part of that whirlwind, and we must defeat it. Thank you.
Thank you, Senator Lee. In defense of Ruth Bader Ginsburg, who cannot defend herself, she disclosed the $1 million award and then announced she was donating it to charity.